Caribbean Court of Justice, Appellate Jurisdiction, an appeal from the Court of Appeal of Barbados, hearing of appeal in CCJ Civil Appeal BBCV number 2 of 2020 between the estate of Marjorie Knox and John Vere Evelyn Deane, Eric Asby Bentham Deane, Owen Basil Keith Deane, Kingsland Estates Limited, Classic Investments Limited, and others. This morning's 5-member panel comprised their honors, Honorable Mr. Justice Saunders, President and Presiding Judge.
Good morning, Council.
Honorable Mr. Justice Witt.
Good morning, everyone.
Honorable Madam Justice Rajnatley.
Good morning, Council.
Honorable Mr. Justice Barrow.
Good morning, Council, and apologies for the grass cutting noise in the background.
And Honorable Mr. Justice Jawada.
Good morning, everyone.
May we have the appearances, please? Thank you.
If it please your honours, I am Alair Shepherd of the Barbados Bar. I appear for the appellant, and with me is Samaya Desai and Philip McQuat.
Yes, thank you. The respondents.
If it please your honors, Doria Moore. I appear on behalf of the second respondent in this matter, the estate of Eric Asby Bentham Deane.
May it please your honors, Barry Gale with Mrs. Laura Harvey Reid for the 10th.
Any of the respondents? Any other respondents? No? To arrange how you will divide that time if more than one of you will be responding to Mr. Shepherd. Mr. Shepherd, are you ready?
I am, Your Honour. Thank you. May I begin then?
Yes, please do.
First of all, Your Honour, dismissed your appellant's judgment, always said its application was for set-off. But your honours will see that I think the application, the affidavit application, is at page 621 of the record. Now, Mr. Justice Worrell denied the application for service of the documents on third parties and granted the orders sought. He granted, and your honours will see that at page, his order is at page 852 of the record. And your honours will see that he granted orders for garnishment in relation to the 9th and second respondent, and he granted a set-off in relation to the 9th respondent, and that order begins at page 854 of the record. Your honours will see that in Judge Worrell's decision, he says at paragraph 4, this court is of the opinion that as regards the 9th respondent, it is to be treated as a matter of set-off, as there is no information before this court to indicate that there has been any share transfer from the applicant judgment debtor. Mrs. Knox is therefore, for all intents and purposes, a shareholder in her individual capacity of Kingsland Estates Limited, the 9th respondent. Now, the actual hearing before Judge Worrell is set up. The notes of that is at page 842. And I'm hoping that I can take your honours through this as quickly as I can. Essentially, at page 843, you will see that Mr. Turney, who then appeared in the matter, said Miss Allard's mortgage is of the shares and was not given with the consent of the company. The mortgage is not registered with Kingsland Estates. Allard is not a shareholder, and that was his submission. Now, in addition to that, the respondents argued before Mr. Justice Worrell that Marjorie Knox, your appellant, had not made any attempt to make the Florida order enforceable in Barbados. There had been no share transfer, so Marjorie Knox was still a shareholder. And they argued, and Mr. Haynes, who appeared for Kingsland at page 847, had argued that the cases which I will come to, that's Roberts and Death and the others, were irrelevant as they addressed garnishy proceedings. And of course, his position was that his application was for a set-off. Mr. Turney, in relation to the insolvency point, argued that it was wholly irrelevant. And then what happened was that there was then an adjournment for the 12th of August for a decision. Now, I'm asking your honors to find that essentially what was argued prior to that was those cases, a number of cases were put before the court in order to show that the court should at least hear the third parties. That certainly was my position. And then the matter was adjourned till the 12th of August. Then on the 10th and 11th of August, your respondents served affidavit evidence. That affidavit evidence foreshadowed the lack of notification, the lack of consent of Kingsland, and also it raised that your appellant had been trying to avoid paying her creditors. Now, at that stage, and I take your honors to page 850 of the record, the third lines, where Mr. Haynes says, in relation to the two affidavits that I have referred to, two affidavits have nothing to do with the arguments which were before the court, have nothing to do with this decision. Mr. Shepherd, QC, can now renew his argument if the decision is given against him. There is no need for an adjournment without a decision being given. Now, if I can just digress for one moment here. This matter was addressed in the Court of Appeal, and Mr. Haynes at that stage, at page 1302 of the evidence, of the proceedings, explains it this way at the top of the page.
What page is this? What page of the record is it?
1302, Your Honor.
I see.
Mr. Shepherd can renew his argument if the decision is given against him. And notice the emphasis on the word renew. It is not to say Mr. Shepherd can commence his argument. Mr. Shepherd can renew his argument. It is a matter for the court as to how far Mr. Shepherd is allowed to go. I simply draw that to Your Honour's attention at this stage, because you have to remember that the two affidavits had been filed. One had been filed a day before. And one of the matters that I wanted was an opportunity to answer, especially since they had alleged fraud. And Mr. Haynes had said at page 50, two affidavits have nothing to do with arguments which were before the court. Now, that is, I think, for what it is worth, what I wanted to bring to Your Honour's attention in relation to that aspect. Now, your appellant then appealed to the Court of Appeal. The submissions before this court are at page 1178 of the record. The fair hearing point is dealt with at paragraph 5 to 12. There were three planks. Firstly, the fact that the documents before the court and the effect of the orders sought meant that Peter Allard, Kathleen Davis and Jane Goddard had a right to be heard. And secondly, the inability to answer the affidavits of the 9th and 11th of August alleging fraud. And thirdly, the failure to allow the appellant to make submissions. And then there was a submission made as to the right of the set-off. My Lord, Your Honours, that brings us now to the decision of the Court of Appeal. And that is at page 552 of the record. That decision, Your Honours, first of all, I say this in passing, Your Honours, but at paragraph 2, this case has a long and sordid history, described by this court in a prior journey of this very appeal as the saga of Knox and Deane litigation. I just say this parenthetically and quickly. I think it is unfortunate that a court of appeal should describe the disputes in this case as being sordid, to somehow mean that they are somehow sleazy, or distasteful, worthy of contempt. But your Honours will see, I think, why throughout the course I regard this as unfortunate. Now, the Court of Appeal then went back to the original issues, the original case, which it said surrounded rights of preemption of Mrs. Knox. At paragraph 7, the court said, on the 29th of June, Kingsland declared a dividend. Mrs. Knox owned 28,570 shares in KEL, and the dividend on those shares amounted to 749 after tax. The respondents commenced garnishee proceedings. Now, again, I say this parenthetically because Mr. Haynes referred to it, I think, at some stage in the arguments at page 1284. The dividend was 749, and the shares which Mrs. Knox had wanted to buy had been sold to third parties at a little more than that. And this was the first dividend. This was the first dividend that had been declared. Now, then the court went on to describe the issues raised in the application, and that is at paragraph 13. It said that the fair trial revolved around whether the third party should be served. No consideration was given to the right to answer the affidavits and the right to be heard on issues other than service on third parties. Secondly, the court considered whether the trial judge had erred in treating the garnishee as set off. And then there was the question of the garnishee, of the award of interest. No mention was made of the arguments before the Court of Appeal as to whether Mrs. Knox was entitled to the dividends, the effects of the trust, the possible insolvency, and the liability of Mrs. Knox to Peter Allard or her entitlement to the dividends. Now, the court then addressed the question of the parties by reference to part 19 of the rules as opposed to part 50 or 49, and by reference to the history of the litigation. And if I can take your honours to that part 50, that is at page 1714 of the record. And if we, because your honours will see, the court approached this matter as if it was addressing whether Allard was a necessary party to the original action, as opposed to considering whether Allard was a necessary party in relation to the garnishment proceedings.
Mr. Shepherd, what page are you taking us to, please, before you move on?
I think, Your Honor, my apologies, I was trying to find it here myself. I think it's at page 1725.
Thank you. And that is part 50, you say?
I think so, Your Honor. I'm just trying to, yes, I have, right. All right, first of all, Your Honours, 1723 is the old rules of the Supreme Court. And that rule at page 1725, Rule 6, if in garnishee proceedings it is brought to the notice of the court that some other person other than the judgment debtor is or claims to be entitled to the debt sought to be attached, or has claims to have a charge or lien upon it, the court may order that the person to attend before the court, and state the nature of his claim with particulars thereof. And then our rules now, which is, yes, the civil procedure rules, which begins at page 1713, that's order 50. And In particular, it is part 50(11). This rule has effect where the court is aware from information supplied by the garnishee or from any other source that someone other than the judgment debtor is or claims to be entitled to the debt, or has or claims to have a charge or lien on it. In this rule, liens the right of possession of goods to protect a debt. Where this rule has effect, the court may require the judgment creditor to serve on any person who may have such an interest as is set out in sub-rule 1, notice and so on. Those orders were not considered in any way by the Court of Appeal. What the Court of Appeal considered was whether Knox and the others were appropriate parties to the original action, which is extraordinary because it was never argued that they were proper parties or ought to have been proper parties to the original action. What was argued was that since they had claims to this money, they had a right to be heard in relation to the garnishee action. Your Honours will see that that is dealt with in the Court of Appeal judgment at paragraph 15, where the court talks about the discretion not addressing, as I have said, Your Honours, the whole question of what were the appropriate parties in relation to garnishee action. There is no mention.
Mr. Shepherd,
Sorry.
please help me here. What is the basis of your complaining about this alleged wrong course taken by the court, the High Court and the Court of Appeal? What is the basis of your complaint?
Because essentially the court was proceeding to make orders in relation to the validity and enforceability of the security documents, for want of a better word, that were held by Peter Allard, the position of Kathleen Davis on the trust instruments, and if the court was going to make some form of order that was going to address the validity or the enforceability of their position, in my view, it had a duty to hear those parties.
Not having heard them, what is the basis of your complaint? What allows you to make the complaint instead of them?
I will come to that, Your Honour. I think I am allowed to do so when I will deal with the cases of Roberts, George, Lee, Martin, Nadell, and Badley. I think that once the court is of the view that there is a doubt as to the validity of, the doubt as to the interest of Mrs. Knox, then the court has a duty either to dismiss the garnishee, number one, or to order that the monies be paid into court and that an inquiry be made as to the equities of the situation. And I think the case is...
You have not helped me at all, Mr. Shepherd. I understand.
Sorry.
I understand what you're saying, but I'm trying to find out why you and not these persons whose interest was not recognized by the court or whose potential interest, why you and not those persons are the one making this complaint.
Oh, I think there are two reasons for that. First of all, they were not served. If they had been served, then they could have made that position clear for themselves. My client's position would have been different. Secondly, there is a question as to my client's position in relation to the trust funds. And if at the end of the day, my client does not, as trustee at the time, make the position, then was she in some way exposing herself to a breach of trust? And thirdly, if my client properly owes money to a third party, and if that third party has been properly secured, then would it be proper for my client to sit back and allow the cost claim to be eradicated by this garnishee order, avoiding her responsibilities that she properly had under the various documents?
Mr. Shepherd, I think I have gotten as much out of you as I will get, and therefore I leave you alone.
I'm sorry, Your Honor, if I haven't. I thought Your Honor was referring me, first of all, to the question of status. What is the status? And I think I will come to that.
I understand why your client would be nobly and perhaps out of a sense of moral responsibility and otherwise interested to see that persons to whom she had an obligation were properly protected, were given every opportunity for justice to be done to them. Your client's position is that justice was not done to them. Your client tried her best. The question is, they now having, in your view, suffered this injustice, why is it that you are the one pursuing the, as it were, the alleviation, the recourse against injustice, and not them? Haven't you done all that legally you have standing to do? That is my question.
Well, I don't think I have, unless I do the appeals. That's the first thing. And secondly, as your Honor will see in relation to the case of Martin and Nadal, which I will come to, there is an argument that if this money is garnished, then my client may also face a judgment in Florida properly enforced in Barbados for breach of trust and the repayment of the same funds. I don't know if I can assist your Honor further. And
I thank you for your contributions. Thank you.
Mr. Shepherd, if that is pursuant to a court order, you say that if the money is garnished, your client may face an action in Florida. But yes, this is pursuant to a court order.
Yeah, I agree, but it doesn't protect my client in Florida.
All right.
That is the case of Martin and Nadal. And perhaps it's just as well that we dispose of that as we're on this. Let me get the case for your Honor.
So, Mr. Shepherd, just a point of clarification, the order of this court will not protect your client either?
No, not in Florida. Because essentially, as I understand it, and let me see if I can bring up Martin and Nadal for your honors. It will not, because it is considered there it is, an execution, and it does not affect, it does not, all right, it's at page 1741 of the record. And it is the case of Martin and Nadal. And if I can read, first of all, from the head note. An action in the High Court resulted in a judgment for £1,400 in favour of the judgment creditors against the judgment debtor, who was a foreign resident out of the jurisdiction. An appeal was taken to the court and the judgment was affirmed. The judgment debtor appealed to the House of Lords, and in order to enable him to do so, he deposited in court a sum of £200 as security for costs, as was required to give a recognizance in respect of £500 as further security. He accordingly made an arrangement with the branch of the Dresden Bank at Berlin, where he resided, under which he paid the bank £500, and the garnishes, the London branch of the bank, entered into a recognizance for that amount. The appeal to the House of Lords was dismissed with costs, which were met by the payment out to the judgment creditors of little more than £300. The balance of £500 not required to meet the costs was 1981, 9 shillings and 18 pence. And the judgment creditors obtained a garnishee order against the London branch of the Dresden Bank in respect of that amount, on the ground that it was a debt due from the bank to the judgment creditor. An order absolute was subsequently made by the master and confirmed by the learned judge, who gave leave to appeal. Now, if it's the judgment of Lord Justice Vaughan Williams. All right. And then from the bottom of page 1740, there is no dispute between the parties to this appeal as to the general proposition laid down in the Exchequer Chambers in Wood and Dunn, following the decision in Allen versus Dundas. That proposition is stated by Baron Channel in giving judgment of the court in the first case that I've mentioned to this effect. The law will never compel a person to pay a sum of money a second time, which he had paid once under the sanction of the court having competent jurisdiction. It is said to confirm the order made in the present case would place the Dresden Bank in a position which these cases recognize as unfair, because the bank might, in proceedings by Nadel in the German courts, be made to pay the amount a second time. There was some discussion as to whether it was the law of Prussia that if Nadel sued the Dresden Bank in Berlin, they could not set up an answer to the action that they had been paid the amount, that they had paid the amount under a garnishee order made in these courts. I do not think that ultimately it was disputed that such payment would be no answer to the action. It appears to me to be clear that a garnishee order is of the nature of an execution, and it is governed by the lex fori and by international law, and an execution which has been carried into effect in a foreign country under foreign law has taken away part of a man's property is not recognized as binding. There can be no doubt under the rules of international law, the Dresden Bank could not set up, oh gosh, this is terrible, and could not set up in an action in Berlin the execution levied in this country in respect of this debt. If we consider the converse case, it is clear and so on. So that is it. The garnishee order does not in any way protect my client from a lawsuit in Florida in respect of this dividend. And in that respect, and I will put this out of the way immediately, first of all, you have the affidavit of Dribbin that I think speaks to the enforceability of the trust in Florida. And secondly, you have, I think, well understood the international rules that would allow that judgment to be enforced in Barbados if it needed to be, because Mrs. Knox would have been then resident in Florida. So in essence, and this was argued before the Court of Appeal, the garnishee order exposes Mrs. Knox, then exposed Mrs. Knox to having to pay the same amount of money twice.
Mr. Shepherd,
Your Honor.
I think you have another 20 minutes, so yes.
Let me go quickly.
Yeah.
Let me go quickly. First of all, we had the question of the validity of the judgment, and I know that I spoke to this very quickly on the last occasion. But if you look at the judgment of the Court of Appeal in Sukar and the judgment of Barrow, you will see that Mr. Justice Barrow concedes that the Barbados 84-2 would have covered the situation, and that in effect, I think, supports completely what your respondents are saying in relation to 84-2, except for one slight matter, and that is this. In this case, and I will deal with the question of the Governor General at a later stage, but in this case, you have the other judge being appointed to the Caribbean Court of Justice, which is the highest court. And for what is this worth, and I say this in passing, I think it is unfortunate to have a situation where this court is hearing an appeal from Barbados in relation to a member of the court. Anyway, that is neither here nor there. The separation of powers, I think we have adequately dealt with in the case of Surendra Singh and Uttar Pradesh. Now, this is at page 14 of the judgment, and I cite this case for a number of reasons.
Do you have the page, the filed page?
You know, I'm going to have to ask Your Honors, my juniors, to give the page, because my copy of...
Aller, the pages, sorry, Your Honors, the pages are, the case is at pages 2502 to 2589.
Thank you.
It is essentially what this case says is that a judgment is the expression of the mind of the court at the time of the delivery of the judgment. And it is against public policy to inquire as to anything that occurred prior to that. It is a delivery made by judges in open court. And against that background, I find it very hard to understand how it can be said that a member of the executive can, while still holding that position, sit and deliver its judgment. If my learned friends are correct in that regard, would not that also apply to a prime minister? A prime minister who was, say, a member of the Court of Appeal, or a minister, best, member of the Court of Appeal, delivers a judgment.
Mr. Shepherd,
sorry,
can the Chief Justice sit as the Governor General?
I think, oh yes, there is a provision in our rules. Most unfortunate. But that is a situation where there is it allows for the Chief Justice to be the Governor General in the event the Governor General is not available. I think it would be stretching to use that section to say that a Governor General could, while being Governor General, deliver a decision of the Court of Appeal.
Okay.
And I think that Surendra helps that considerably. Now, the set-off point, if I can deal with that very quickly, and can I take you back now to the judgment of the Court of Appeal? And particularly at page... It's at paragraph 24 of the judgment of the Court of Appeal. The court says, in the instant case, Mrs. Knox was a shareholder, dividend is declared, the ex parte order is made, and then on the 13th of July, this is paragraph 26 at page 565. On the 13th of July, Kingsland, the 9th respondent, applied by affidavit for an order that KEL set off the sum of 284 with interest. Then it says, after dealing with the issue of garnishment at paragraph 28, it is clear on this record that there was no basis for attacking the garnishment order of the trial judge. Notice was clearly served on KEL, indicating that the dividend to which Mrs. Knox was entitled was liable to be attached by garnishment. There was no basis which could be contended that the garnishment order should not have been made absolute by the trial judge. Trial judge, since all the procedural requirements of the rule were complied with. As concerns the set-off, and then it turns to deal with at 31. A set-off is a defense in an action for payment. See Stook and Taylor. The plea can only be used in the way of defense to the plaintiff's action as a shield, not a sword. It must be noted that a set-off is not a method of enforcing a judgment and is unconnected to garnishee proceedings. Consequently, Kingsland, the 9th respondent, who applied by affidavit for an order that it could be committed to set off the sum against the dividend which it owed to Mrs. Knox, was entitled to a set-off. However, Deane were entitled to garnishment. And then the final sentence. Hence, the trial judge erred in treating the garnishee proceedings brought by the 2nd and 10th respondents as an application to set off. But they never did. And I have struggled to understand the position of the court in relation to this set off, having concluded that the set off was not appropriate to enforcement proceedings. It then proceeds to dismiss the appeal on that ground. Now, Your Honours, I know I'm running out of time, but I just want to say this very quickly. We submit that the garnishee order should never be made absolute, where there is evidence to suggest that the judgment debtor is not entitled to the funds. We say it should not be made where there is grounds for believing not only the shares but the dividends are subject to a lien and trust. Now, the entire court dealt with this matter in relation to the ownership of shares. That's section 179. I will come to that. But nobody seems to have considered the ownership of the dividend itself, especially given the provisions of the Barbados mortgage, to which there was, for which there was, as we now know, which we now know exchange control, and in particular, paragraph 5 of that mortgage, which states clearly, the mortgagee hereby agrees with the mortgagor that until it shall have made demand for payment on the mortgage, the mortgagee will hold all dividends paid on and received by it in respect of the shares for the accused of the mortgagor, and will pay such dividends to the mortgagor upon being called upon to do so. So there was clearly in the mortgage itself a provision by which Mrs. Knox had alienated her right to the shares. Again, there was some suggestion made that that mortgage needed to have been registered with corporate affairs and or with the company. I do not see any provision for that. And perhaps my learned friends will speak to that during the course of their arguments. Again, the garnishing order should not be made if to do so would be to favour one creditor over the others. And I appreciate, my lords, your honours, that I cannot speak to the order refusing us leave to put in additional grounds. But I think I can speak to the fair hearing point in this way. There was suggestions that Mrs. Knox did not own the shares and was impecunious. In affidavit evidence that could have been put before the court to ground arguments. Again, your honours, in relation to the case of Badley, that you don't make a garnishee order when there is evidence to suggest that the debtor cannot deal with the funds without violating the rights of the others. And then finally, there is the question of the case of Fraser and Oyster Tech, which is at tab 4, page 2484, under which we say that, again, there was reason why the garnishee order should not be made. Now, essentially, I will deal with this. Essentially, as I understand the Court of Appeal, they felt that section 1794A was a complete answer. 1794A does, in fact, we know, prevent or seek to prevent the beneficial interests of the shares moving. It does not, I say again, speak to the interest of others in the dividend itself as opposed to the shares. Secondly, we say that section 1979 is to be dealt with in relation to a transfer of shares that is envisaged by that section, and that one has to be very careful about it in relation to the trust position. And in that regard, I can only refer your honours to the Buckley that we have at page 1417 of the record, which I think clearly supports that position. So essentially, my lord, am I at the end of my hour?
You have about 10 minutes.
I'm not. I think, Your Honours, I think I have dealt with everything that I have passed over, everything that I wanted to bring to Your Honours' attention. I think I don't know whether I need to take Your Honours in any detail to the case of Fraser, and I will assume that that has been read and Your Honours understand the point about the flawed asset and the circumstances in which we say it would have been inequitable and unfair to have made this garnishing order. And I don't think there is anything further I can assist Your Honours with, unless, of course, there's something in particular that Your Honours would like to hear me on.
Yes. What exactly are you asking the court to do?
All right. Thank you, Your Honour. First of all, I have to admit that in conversation with my learned friend, Mr. Gale, we spoke glossingly about what would happen in the event that the court came to the conclusion that the decision of the Court of Appeal was a nullity for those grounds. And I think we both said at the time that it was probably better, given the passage of time, that this court decide the matter as opposed to referring it back to the Court of Appeal. To a large extent, I do not derogate from that, save for the fact that I think personally the whole question of the Governor General sitting while Governor General as a member of the court, Your Honours may see as important enough to say, no, we cannot tolerate this kind of infraction on the separation of powers, and we are not going to deal with the decision and send it back.
I got you. You've heard your arguments on that.
Right. Now, secondly,
yes, proceed.
Secondly, in the event the court comes to the conclusion that the cases that I have submitted to the court, under all the circumstances, do not warrant the garnishee absolute being made, then I would invite this court to simply allow the appeal and set aside the garnishee absolute. In the event that this court was uncertain and accepted that the third parties ought to be heard, then I think this court has a duty to remit the matter back to the High Court for rehearing with service on those parties.
Well, that would be no different from the eventuality that we find that the garnishee nisi order should not have been made absolute, because then, or perhaps not, if we find that the garnishee the order should not have been made absolute, then in your view, that would be the end of those garnishee proceedings. I see. But if we find,
yes, Your Honor.
But if we find that there was only a breach of natural justice in the hearing, then you're asking that it be remitted for the relevant parties to be heard. Is that it?
Correct, Your Honor. Correct.
I see. Yes. Does anyone else have any questions of Mr. Shepherd? No? Okay. Okay. Well, I must compliment you, Mr. Shepherd, for staying within your time. We really appreciate that. And we thank you for your submissions.
Not without a huge effort, Your Honor.
But it's all done on paper, so you won't be prejudiced anyway, I assure you.
Thank you, Your Honor.
Yes, you're welcome. Mr. Gale, or is it Mr. Haynes? I'm not sure. Or Ms. Moore?
I think.
Please, Your Honors.
Before you start, I think the idea is that the respondents together have also 1 hour. Is that?
That's correct. You will divide up that hour among them as they think best.
That is clear. Let me start, Your Honors, by referring you to, and it's there in the submissions, referring you to Order 49 of the Rules of the Supreme Court.
1724.
Order 49, at page 1724 of the record.
And following.
And following. Order 49, Rule 5 says this: where on the further consideration of the matter, the garnishee disputes liability to pay the debt due to the claimant, debt due or claim to be due from him to the judgment debtor, the court may summarily determine the question at issue or order that any question necessarily determine the liability of the garnishee be tried in any manner in which a question or issue in an action may be tried. The garnishee in this case is the 9th respondent, Kingsland Estates Limited. Kingsland Estates Limited disputed that it was liable to pay the entire debt to the garnisher, and it was a very simple case. Costs were given in favor, awarded in Privy Council costs were awarded in favor of Kingsland Estates Limited to be paid by Marjorie Knox. So any dividends due to her were to be set off. The judge summarily determined this matter, and it need not have gone any further. My learned friend speaks of a set-off is an action in a defense for payment. But that is not entirely that. Yes, that is a fact. A set-off is an action in the defense for payment. But that is not only what a set-off is. A set-off is also automatic and self-executing. A set-off can be used where A says to B, you owe me $10, I want payment now, and B says, well, you owe me $5, so I'm only paying you $5. A set-off is a self-help. It is self-executing. It is not only to be used as a defense in an action for payment. So one cannot confine a set-off to defense and an action for payment.
So just make that point on the facts of this case.
On the facts.
Apply that on the facts to the facts of this case.
On the facts of this case, Your Honor, Kingsland Estate, Marjorie IIma Knox was indebted to Kingsland Estates Limited. Marjorie IIma Knox was the shareholder on record of was a shareholder on record with Kingsland Estates Limited. Kingsland Estates Limited declared a dividend. As a shareholder, Marjorie IIma Knox Marjorie IIma Knox was entitled to part of that dividend, or to her share of the dividend. And as well, Kingsland Estates Limited was entitled to say, I owe you $200, but you owe me 150, so I'm only paying you 50. That is my way of set off. The
Mr. Haynes, perhaps you could assist me.
Yes, Your Honor.
If there were no extant garnishing proceedings, if there were no garnishing proceedings whatsoever, what would Kingsland Estate properly do if they wanted that set up?
Kingsland Estates Limited could have done it in one or two ways. Kingsland Estates Limited could have sent a statement or the balance of the funds. In other words, we owe you a dividend of $200. You owe us $150. Enclosed, please find a check for the difference being $50. If there were no garnishing proceedings. In Kingsland, knowing that anything that you do would become contentious, you have the alternative of going to the court and seeking a declaration.
Well,
in a sense, therefore, counsel, of what Kingsland was seeking to do was simply leave out the term set off, simply to withhold a part of the payment of the dividend, correct?
Indeed, Your Honor.
And say it's not subject to garnishment.
And say that it is not subject to garnishment. I have the money. This belongs to me. I set off first.
Maybe the word set off is not the correct terminology in this particular situation. I do think that paragraph 31 of the Court of Appeals judgment sounds pretty confusing to me. I don't know what you think.
Let me say this, Your Honor. In my submissions to the court, I would try to avoid the Court of Appeal judgment as much as possible.
Mm-hmm.
I don't know if that conveys the impression. But
I think you're simple. Is it not correct that what you just said to us, I believe, is that insofar as the Court of Appeal limited set off to a defense in an action for payment of money due, you are saying as a matter of law that is too limited and restrictive a definition. That in the circumstances of this case, as a question of fact and law, the Kingsland Estate was entitled to set off from the money it owed to Marjorie what she owed to it.
Yes, Your Honor.
Simple.
Correct.
Yeah.
Maybe it's
just I like the term withhold.
Yes. Maybe it's just a matter of language, because if you will withhold that particular part and you tell Mrs. Knox we are withholding this, then she would come with a case asking for the whole amount of money, and then you would say as a defense, but I have this amount. So it's just practical thinking, and I don't think we should pay too much attention to the word of set off.
Indeed, Your Honor. If I may move on, the cases, there's dicta in the cases cited by my learned friend, Mr. Shepherd, in relation to set off. In the cases of Fraser, in the context of garnishment, Fraser, and cited by my learned friend Fraser and others, and Oyster Tech PLC and others at page, what page of the record? Oh, at paragraph 6, Your Honors. At paragraph 6, and
that's paragraph 6 of
the Fraser case.
Oh.
We have it right there where he quotes the dicta of Blackburn J. I agree that no greater right is given. I agree that no greater right is given to the creditor than the debtor had. It is obviously just that if a cross debt were due to the garnishee at the date of the attachment, there should be a right of set-off in his favor, and I should strive hard to give effect to it if I could, though there would be difficulties in the way. But Mr. Williams goes further and maintains the right to set off debts accruing after the attachment. For this I see no ground. And in the case of...
Mr. Haynes, what page is that, please? Just a reminder.
Paragraph 6 at page...
Scroll up. Scroll up.
Scroll up.
I can see the page. That's not the record.
Barry, what page is that in the record?
Of what, Fraser?
Yes.
2484.
At page 2484 of the record.
Thank you very much.
I'm going to hear now.
Yeah.
The other case cited by my learned...
2480. Yeah.
The other case cited by my learned friend in relation to this set-off point is the case of Hale and Victoria Plumbing Company Limited, and that is at page 2480 of the record. And at the penultimate paragraph of the judgment of Lord Justice Dankworth. Come down. Last page, yes. It seems to me, on the final page, it seems to me to be contrary to justice and sense to order that a garnishee should pay out money which it appears probably will not be due from him at all, because no proceedings have been taken by the judgment debt against the garnishee any more than any proceedings have been taken by the garnishee against the judgment debtor. It seems contrary to justice that an order should be made for payment of monies which on the face of it appear not likely to be due and which might perhaps be paid away irretrievably to a man or company who is in trouble. So that on those grounds, we say that Kingsland Estate Limited is entitled to withhold the money, rather than use the word set off, the money that was due to it. With respect now to the separation of powers point, I understand my learned friend.
Just a minute. Before you get to the separation of powers point.
Yes, Your Honor.
Are you going to deal with the issue as to the natural justice issue as to whether the court was under an obligation to hear from these other parties?
Yes, Your Honor, to a certain extent. My learned friend, Mr. Gale, will deal with it in more detail. But I am going to touch it slightly. I am saying, my lords, on that point, if I just, since the court has taken me there, let me say, my lords, your honors, and I now turn to Rule 6 of the Supreme Court Rules, Order 49, at page, what of the record?
1725.
At page 1725 of the record. That's the Supreme Court Act.
1725.
At page 1725 of the record. And Rule 6 says this. Rule 6 says, if in garnishee proceedings it is brought to the notice of the court that some other person other than the judgment debtor is or claims to be entitled to the debt sought to be attached, or has or claims to have a charge or lien upon it, the court may order that person to attend before the court and state the nature of his claim with particulars thereof. That, as I understand it, is the basis of the argument of the appellant. If in garnishee proceedings it is brought to the notice of the court that some other person other than the judgment debtor is or claims to be entitled to the debt sought to be attached, or has or claims to have a charge or lien upon it, the court may order that person to attend. Now, what has happened in this case, basically, is that the appellant has come to this court and has said, essentially, there are people here who may have may be entitled to the debt, or may have a charge or lien upon it. When one looks at the documents in support of that allegation by the appellant, one will note that you don't know, Marjorie. We are just saying that it is a bold allegation. Are you there? We are saying, my learned friend is saying that I'm going into his arguments. All I'm saying, Your Honor, is that it is a bold allegation. Because, and when looked at, it has no substance for two simple reasons. One, that the shares were registered in the name of Marge Knox in the company's records. Two, to date, up to today, no share transfer form has been provided. And Section 179 deals with the situation of the Companies Act. Two, the dividends that Mr. Allard claims to have a charge or lien over, when one looks at the mortgage itself, there is no charge on the dividends. The only thing that is charged is the shares of the Barbados mortgage. So if you look at the Barbados mortgage, there is no charge on the dividends. So the dividends aren't attached. And irrespective of what my friend says to the section that he quoted, the section that was quoted at what? Yes, the mortgage. Yes. Yes, at page 968 of the record, my learned friend, Mr. Shepherd, for the appellant, referred the court to section 6, clause 6 of the mortgage, and which states the mortgagee hereby agrees with the mortgagor that until it shall have made demand for payment on the mortgagor, the mortgagee will hold all dividends paid on and received by it in respect of the shares for the account of the mortgagor, and will pay such dividends to the mortgagor upon being called upon to do so. That presupposes that clause presupposes that dividends fall into the hands of the mortgagee. But according to the mortgage and the charging clause, dividends do not fall into the hands of the mortgagee. So with respect to, and lastly,
can I just ask a question?
Yes,
you have given us this explanation. Did the first instance judge, Justice Worrell, or the Court of Appeal undertake this analysis that you have so carefully done and say that, well, Rule 6 provides that if it is brought to the attention of this court that some other person is entitled to debt or has a charge on it, well, we have a discretion to order the person attend and to deal with the issue summarily, no problem. However, in the exercise of our discretion, we will not make any order as requested because, and then say exactly what you said. Was that done by Justice Worrell or in the Court of Appeal? Or anything similar to that? In other words, the question is the natural justice point. How was it dealt with?
And before you answer that, Mr. Haynes, was Order 49, Rule 6 brought to the attention of Justice Worrell?
Indeed it was.
That was the rule you guys
That was the rule that we brought. The applications were brought under Order 49.
You mean the part that says that you may order the person to attend?
Order 49, Rule 6.
Was that specifically brought to the attention of the judge, or did the judge allude to it in any way?
I don't know what. I don't know if the judge alluded. I don't know. It doesn't. The judge did not allude to it in his judgment, but the garnishment proceedings were brought under Order 49 of the Rules of the Supreme Court. The application to serve on third parties, the claims of third parties, is referred to in Order 49, Rule 6.
Okay, let me ask this another way.
Yes.
I get confused with these appellants, respondents. Did counsel for Ms. Knox say to Justice Worrell, I'm asking you not to grant the garnishee, nice absolute, not to make it absolute, because there are these other parties who have an interest and who you should hear before you make this order absolute?
Your Honor, I do not know if he said it in those exact words. It's a long time now, but the effect of what he said was what the court, you just said, Your Honor.
I see.
Do not make this order absolute because there are third parties who may have claims on these monies.
So, and before you make any order absolute, you should have papers served upon them. That's what the other side was saying. So the question of bringing them before the court was raised centrally to the judge.
Yes, Your Honor.
So my question, Mr. Haynes, was, did the judge address it in the way you have done before us, or at all?
I don't think the judge addressed it in the way I addressed it before, Your Honors. But obviously, other than paragraph 4 of his decision, where he said, this court is of the opinion that as regards the ninth respondent garnishee, it is to be treated as a matter of set off, as there is no information before this court to indicate that there has been any share transfer from the applicant judgment debtor. And it goes on, Mrs. Knox is therefore to all intents and purposes a shareholder in her individual capacity of the Kingsland Estates Limited, the ninth respondent.
This has to be read in conjunction.
And when you read paragraph 4 of the judgment, which is at page 854 of the record, when you read that in conjunction with paragraph 3, he says this: the court heard submissions on behalf of the ninth respondent, garnishee, the second respondent, first judgment creditor, 10th respondent, second judgment creditor, and the applicant judgment debtor, and having read the relevant affidavits filed herein by Gerard Martin Cox, Eric Asby, Bentham, Deane, and John Knox, acting on behalf of the applicant judgment debtor, the court denies the application on behalf of the applicant judgment debtor for service of documents on any other party, or that matter be adjourned for any purpose.
And in paragraph 4, he purports to give on the merits why he thinks that was an appropriate decision. Yes. That is to say that Mrs. Knox, for all intents and purposes, remains a shareholder in her individual capacity. Correct?
Correct, Your Honor.
So therefore, in your submission, the trial judge addressed this issue and gave reasons to support the exercise of his discretion not to join or serve.
Indeed, Your Honor, and taking into account Order 49, Rule 5, the court may summarily determine the question at issue. I believe that is what Justice Worrell did.
And the Court of Appeal also had a similar inquiry and decision?
They considered the document.
They considered
The Court of
documents.
Appeal considered the documents at the end of the day and upheld the decision of Justice Worrell.
Not to say.
But in my view, I mean, my submission is that the Court of Appeal's judgment really is
Correct, not holding the oath.
is correct, perhaps only in
The result.
the result and nothing else. But that is my view. So if I may just, I don't think that there's anything else that I have to add, except one point on the separation of powers. The section 84(2) of the Constitution must be interpreted purposefully. It's a purposive interpretation of the Constitution. And what my learned friend is saying essentially is that section 84(2) of the Constitution, if the court will, if your honors will interpret it, that say any judge who has resigned or retired can deliver a judgment. What my learned friend Mr. Shepherd is saying is that section 84(2) of the Constitution is unconstitutional because it fails to obey the separation of the doctrine of separation of powers. So what my friend is doing is putting the doctrine of separation of powers be above the Constitution. Section 84(2) of the Constitution cannot be unconstitutional if interpreted in the manner, in its literal and purposive interpretation. And it is there for a purpose. So to ensure efficiency and delivery of judgments. Unless there's anything else, Your Honors, those are my submissions.
You think that this decision, you said to ensure efficiency from the date this case was finished before the Court of Appeal until the date of the judgment, would you say that that was an efficient use of Section 84? Is that what the intention was?
No,
because you have addressed the separation of, and you talk about a purposive interpretation. If the intention was to facilitate the effective and efficient delivery of justice, would you say that was achieved between the time this case was finished in the Court of Appeal and the decision you got?
The answer to that, obviously, Your Honor, is no.
Okay.
Because the Court of Appeal took far too long with this judgment. The Court of Appeal, anyhow, I say no more of that. The respondents and the appellants, the respondents and the appellant did their best to ensure that to inquire as to when the judgment would be delivered. But of course, as parties to the case, we have no control over the delivery of the judgment. I think those are my submissions, Your Honors, unless there's anything else.
Yes, thank you.
I just have a few questions here. And this goes into hypothetical situations, but I need that to get a proper idea how to interpret this Section 82. Mr. Shepherd said, well, suppose Justice Mason had become Prime Minister. Would she still sit?
We say in purposive interpretation, that person would still be able to sit and deliver the judgment. Because they would not be sitting as Prime Minister, they would be sitting in accordance with Section 84(2) of the Constitution. That is as a retired judge or a resigned judge.
Still subject to the oath.
Just a minute.
Still subject to the oath.
We've been all along saying sitting and delivering. Was the court actually convened and did then, well, the Governor General appear in court in her robes and sit and deliver the judgment?
No, Your Honor.
Okay.
In fact, and to be frank with the court, neither there were two judges of the court missing who did not sit, and that was the Governor General, Sandra Mason, Justice of Appeal, yes, and Justice of Appeal Burgess.
Yes, so we're really concerned here with signing a judgment that is delivered while they hold their respective other positions.
Yes.
Indeed, Your Honor.
Yes.
And finally, we say that even if this court were to say that that judgment was irregular or there's no jurisdiction to deliver that judgment, that does not affect the basic case. And the basic case is this, that we say that Justice Worrell had before him absolutely no evidence to raise even a prima facie case that third party should have been summoned to appear before him.
Can I ask one more question on the issue on the composition of the Court of Appeal? Now, of course, there actually, if Mason and Burgess had sat according to the Constitution, they would have been sitting to deliver a judgment as persons, not as judges, actually. But anyway, if this had been a case against the government, or even a case against the Governor General, could the Governor General still sit in this situation? It's a little, I take it a little to the extreme, but the point is, how broad can this be read? I read the text of Section 82, but surely at some point there must be limits to what can be done properly. But I'm just interested in your answer. Do you think if this had been a case against the government or the Governor General, if the Governor General could have sat? I mean, the point that Justice Burgess is now a member of this court is not very important to me, because we may differ of opinion and dissent from each other as much as we want. That's all normal business. But a Governor General sitting to deliver a judgment in a case against the government or the Governor General, that would still be possible given the text of 82?
Given the interpretation that we say that we submit in respect of Section 84(2), that would still be possible, but other considerations would then come into play.
Yes.
And the Governor General may say, no, in these circumstances, it is best that this case be retried, because this is an exceptional circumstance.
Yes. Okay.
She cannot take the oath of Governor General.
Yes, Mr. Haynes, sorry, Mr. Gale, is it?
Your Honours, may I respectfully request, in cricket terms, a water break?
Yes, we could take a break. We will, it's now, this clock I'm looking at, 11:31. We take a break until 11:40.
Much obliged.
So you can remain on screen, turn off your cameras and your microphones, but bear in mind that if you did that, whatever you say, we might be able to hear it.
Vice versa.
Thank you.
Yes, Mr. Haynes, Mr. Gale, sorry.
Well, in that case, Your Honor, I will see the balance of my time to Mr. Gale. Right. Okay, that's all. You go ahead, Barry.
May it please Your Honors. Are you hearing me okay? Yes. These submissions are being made on behalf of the 10th respondent, Classic, as well as the second respondent. And in the limited time available to me, I'm going to deal very briefly with the history of this matter. And the reason why I want to deal with the history of this matter is because when the matter came before Worrell J, and he was being asked to exercise a discretion as to whether or not he should serve what were purportedly interested third parties, he was entitled to look at the context and the history of these proceedings. That's my first submission. Now, I'm late to what is proverbially called a party, because I only got involved in this matter in June 2020, following the demise of Mr. G.C. Turney QC, who happened to be a mentor of mine. So I'm new to the proceedings. That perhaps gives me an advantage, because even though these proceedings have been ongoing for over 20 years in multiple courts, in multiple proceedings, I believe it's important to look at the whole context of what's going on here, because the way I see it is that this issue, even though it's narrow in terms of garnishment and whether or not Worrell J correctly exercised his discretion in not ordering service on the purported interested parties and making the order absolute, he was entitled to look at the context of the matter before him and the history of the matter before him. Now, the history of this matter is that even though it began in 1998, 20 years ago, High Court gave its decision in 2001. Court of Appeal gave its decision in 2003. That's 18 years ago. The battle was over in 2005 when the Privy Council gave its decision and awarded costs against the respondents. That's 15 years ago. What's happened since 15 years? There has been multiple proceedings, and it's in the record, in several courts, and the latest episode is really this one. And what does this one seek to do in terms of what the appellant is trying to achieve? My submission is that the appellant, as she has been doing in concert with her children and her well-known multi-millionaire financier, Mr. Peter Allard, is to frustrate the respondents wholly in the collection of costs awarded in all courts. Your lordships, and particularly you, Justice Saunders, and you, Justice Witt, were involved in the 2011 CCJ matter that came before you on security for costs. In those proceedings, a history was given when at that time in 2012, there were 5 sets of proceedings pending in various courts relating to the only outstanding issue, which is between these parties, and that is the assessment of costs and the payment of costs. That's the only issue. We are where we were in 2012. The High Court costs are still subject to review. The Court of Appeal costs, as awarded by the Court of Appeal, has not been taxed because we're waiting on the High Court costs. The only costs which are certain are the Privy Council costs, which were taxed and are undisputed, and it cannot be disputed because they've been registered as judgments in Barbados. So this is the latest attempt, in my view, to frustrate the respondents recovering their costs as awarded, specifically in this instance by the Privy Council. And when Mr. Shepherd appeared before Royal J, having filed an affidavit by John Knox, shortly before he was to consider whether to make the order absolute, attaching all of these documents, 2 declarations of trust, 2 mortgages, a stock power. It was for one purpose. And I submit the purpose was to delay and frustrate the enforcement of the Privy Council costs. So that's set in a high level historical context. And that's all I would say about that. What I will say is that questions were asked or discussions were had with Mr. Shepherd about conversations between us. If your lordships should rule in a certain fashion, whether it should be remitted back to the High Court and so on. Let me make our position very clear. It would be a travesty of justice, a disservice to the parties to send this matter back anywhere else. And if your lordships have the ability to determine this matter, I would invite you to please do so, because we need finality. These parties need to get on with it. You will see from the documents, according to the stock pledge agreement, Mr. Allard is supposed to have advanced Mrs. Knox $34 million to assist her in her litigation costs. Well, you know what? On this side, the respondents have incurred substantial costs running into the millions of dollars. And remember this, we have not to date recovered 1 penny. That's what was before Royal J, and that's what was before, by extension, the Court of Appeal in 2005. Now, I want to
just Mr. Gill, those dividends, the proceeds of those dividends, they're being held in escrow someplace?
In court.
They're in court.
They're in court, I see.
They're paid into court. Now, I'm going to start where my learned friend started, Mr. Shepherd. He complained of the words long sordid history as used by the Court of Appeal and said it was inappropriate. On the contrary, my submission is that it is more than appropriate. And indeed, the Privy Council, the Court of Appeal, and this court has commented adversely about these litigation battles which have been ongoing. I believe it was described by this court as a long-running internecine family dispute. That's what it was. That's what it is. And we need to see through this. And I want this court to see really what these respondents are up to in their arguments about service. Appellants, sorry, these appellants. And we say that under sections 38.1 and 61.1 of the Supreme Court Act, this court, like the Court of Appeal, has both a duty and a power to resolve all issues in dispute at this stage, and it should resort to those powers in making a final determination insofar as it can in relation to the current dispute before the court, and not seek it to send it back anywhere else. Now, the only other point of a general nature which I would make is that I was talking about frustration of recovery of costs. In the same vein, you have a number of transactions which were entered into between Mrs. Knox, the appellant, and Mr. Allard, principally. You have 2 declarations of trust, one in Barbados, one in Florida. You have 2 mortgages, one in Barbados, one in Florida. What do they together do? And when were they effected? Well, if you look at the historical context, the first mortgage was 2002. The declaration of trust was 2002, where Mrs. Knox purports to hold herself as trustee for 2 of her children of her only known asset in Barbados, her shares in Kingsland. She attempted to give it away under that trust. Then she enters into a mortgage with Mr. Allard in the same year, 2002. And what's happening? You got proceedings in the High Court. You got proceedings in the Court of Appeal. And then what happens after that? Well, here comes the revocable declaration of trust in 2007. When was that done? That was done at a time when there were proceedings before the Court of Appeal. That's not accident. That's not accident. And again, that trust, subject to the laws of Florida, this time she tries to transfer the shares, her only known asset, to her daughter, Kathleen Davis, now in trust for all 3 children. And it's a revocable trust. And then the next one is the stock pledge agreement in favor of Mr. Allard, her financier. When was that done? 23rd of November 2010. Guess what? The appeal gave leave to appeal in these proceedings on the 10th of September 2010, 2 months before this stock pledge agreement was executed in favor of Mr. Allard. And what does it secure? An outstanding amount of money, staggering sum of $33 million. Now, I wonder when you look at all of those together, what conclusion you come to. Well, to me, the inescapable conclusion is, and it must be something that World may have considered, I don't know because we have a very abbreviated judgment, but certainly that was the background. They were trying to put their assets, Mrs. Knox was trying to protect her assets against adverse cost orders. That is not the issue for you to determine today, I accept, but it's part of the historical context. Now I'll deal with the garnishment proceedings, legal and beneficial ownership of the debt. So the only issue before World was one of enforcement, we know, of an undisputed debt. In other words, the Privy Council costs as taxed. The main issue for determination, as you will know from the record, is whether, given the facts, all the facts and circumstances before him, he should have made the garnishee order absolute, or accede to the request by counsel for Mrs. Knox that the proceedings be adjourned and that there be service on these so-called interested third parties who may have an interest in the dividends which was sought to be garnished. That was the only issue. And that was the major complaint of the appellant, was that given all these documents that we've now thrown before you, Judge Worrell, here it is, there's a prospect of a third party having a claim, and therefore you should order service. So we go to Order 49, which Mr. Haynes has taken you to at pages 1725 of the record. And Rule 6, and by the way, it was agreed that Order 49 was the applicable rules. There's mention to it in the Court of Appeal decision to another order that was inapplicable. So you're focused on Order 49.
Mr. Gill, did these third parties ever seek to intervene in these proceedings?
My Lord, the answer to that is no. And I will elaborate to say they did not seek to do that, even though they clearly had expressed notice of the garnishment proceedings. I'll make that point in a minute.
Okay.
By reference to the record. Now, clearly under Order 49, Rule 6, the court has a discretion because it says it may order. When you read the cases relied on by my learned friend, particularly the Death case, it's called Robert Death case, It would seem that if I can summarize what the test is for a judge, considering whether to make an order for service, he makes an order for service as those authorities show, if he considers that it would be just and equitable to do so. Just, which is a white test. And the cases are one that the jurisdiction under garnishment is a equitable jurisdiction, undoubtedly. So he had to look at all the facts and circumstances, the documents before him, which he looked at, because they were in the affidavit to John Knox, and he said he considered that affidavit in giving his judgment, and decide whether in these circumstances it would be just and equitable. Now, because it's an exercise of discretion, it is trite law, of course, that my learned friend and the appellant would have to show that Judge Worrell was clearly wrong in the exercise of that discretion, in the sense that he failed to take into account relevant considerations, irrelevant considerations. I don't need to tell you the law. It is too well known to you, to me to expound on that. That is what the hurdle he must jump. And we say a hurdle that he cannot, in the circumstances, jump, in this case. So,
I think we were pointed to by Mr. Haynes, paragraphs 4 and 5 of the judgment of Worrell J, where he both alluded to the relevant rule and therefore addressed his mind to the relevant law. And in paragraph 5 it was, or maybe 3 and 4, I've forgotten now, but in the following paragraph, albeit maybe in a very truncated form, addressed facts, therefore one can say merits, as to whether or not, I mean, his simple factual analysis was that the share remained in Marjorie Knox's ownership. So if that, two questions on that. One, well, clearly he addressed his mind to the right rule. So on the second aspect, A, was his analysis of the facts right? I.e., on the facts, was it correct that Marjorie Knox remained the owner of the shares? And two, if that was right, was that the only material consideration? Because it's not just considering irrelevant matters, but it's also addressing your mind to what is relevant, right, in the exercise of a judicial discretion. Was that the only relevant matter that he ought to have addressed his mind to in this case?
So let me answer that, because and thank you for taking me to that paragraph of the judgment, because I was going there next. It's important to note the language that Justice Worrell uses at paragraph 4, because he says in the last 3 lines, this is page 854 of the record, Mrs. Knox, therefore, for all intents and purposes, a shareholder in her individual capacity of Kingsland Estates, the 9th respondent. So he says for all intents and purposes. Very wide. Now, he made that statement in the context of what was before him. And what was before him were all these documents, the 2 trusts, the 2 mortgages.
Just to be very, very precise, would you say that on the evidence was an accurate, a true conclusion?
Yes, and I will explain why, by reference to the documents. Now, I have to admit that we all could have benefited from a judgment from Worrell J, which set out the reasoning in some detail for his conclusions, because all he's set out here is a conclusion, really, in paragraph 4. And while I'm on it, I'm going to take the opportunity of agreeing with my learned friend, Mr. Shepherd, that the Court of Appeal erred when it considered the question of joinder. That was not the issue before the judge, Worrell. It was simply one of service. And Mr. Shepherd has, in his submissions in this court, his reply submission said that we were entitled, they were entitled, both parties were entitled to a decision on 1 point, and 1 point alone, and that is service. And I agree, because that was the issue raised before Worrell J, which is, given the documents, given their potential interests, it would be right, fair, to use the words natural justice point, the point taken by the president of the court, to serve these documents on these third parties. That was in substance it.
Mr. Gale, was the company a party to all of these documents, agreements, mortgages involving Mr. Allard?
Missions.
No, the answer to that is no.
Okay,
And
then, okay, fine, no. As a matter of law, is the company entitled to pay dividends to, in the absence of it being a party to any of these other arrangements? Is the company entitled to pay dividends to any entity other than the shareholder?
the answer to that, Your Honor, is no. Section 170 of the Companies Act sets out basically that you have to have a record of who the shareholders are. And the purpose of that, Section 170, which goes on to deal with not taking notice of a trust, is that the company is not concerned with anybody other than the shareholder.
What
When
section is that? Sorry, Mr.
170,
170, right, sorry, thank you.
the Companies Act.
Yeah.
I'm not sure what page of the record it is.
170 and then 171.
And then 171. And 171 is pertinent because you have to read the two together. But 171.1 says, except as provided in this section, notice of a trust expressed, implied, or constructed must not be entered by a company in any of the registers maintained by it pursuant to Section 170 or be received by the registrar. Now, the whole purpose in my submission of 171 is to confine the company's inquiry in determining who to pay the dividend to the share register. They don't have to look behind, or they don't have to be worried about, is there a trust hidden somewhere? Does somebody have a hidden claim to these dividends? So I hope that answers your lordship's, your honor's point.
Thank you.
Moving on. When you look at the, and I don't think I have time to deal with this, but when you look at the record of the transcript before Worrell J, which is to be found at pages 842 to 851 of the record of appeal. When you look at, and I'm going to ask you to do this in your own time because I don't have time. When you look at the arguments which were advanced by counsel, particularly for the respondents, you will see, and these were arguments which were submitted by reference to the documents. The arguments included one, that the Barbados Trust had been revoked by the Florida Trust. That's page 846 of the record. Two, the Barbados mortgage did not attach to the appellant's dividends. Page 847 of the record. My learned friend, Mr. Haynes, has already dealt with that by reference to clause 5 of the mortgage. Three, there was no valid transfer of shares by the appellant under Barbados law to the Florida Trust, given the provisions of sections 171 and particularly 179 of the Companies Act. In fact, 179 really is the key provision that your lordships, your honors really need to look at. because that section has the effect of preventing, in law, in respect of shares in Barbados companies, any beneficial or legal interest passing to anyone under any document, including a trust. And in that regard, your lordships would look at 179, subsection 7. I don't know if you can bring that up, anybody. But what that says, and I'll read it in the meantime. 79.4. Having a difficulty finding it.
You're on 79.
79.4. Just bear with me a minute. I'm just looking for the provision. There it is. 79.7, sorry. 179.7. It says, this section applies notwithstanding anything contained in the articles or bylaws of a company, and notwithstanding anything contained in any trust deed or debenture or any contract or instrument. And let's go up a little bit on what 179.4 says. This has to be read in the context of 179.4. A. So subsection 4 says that the beneficial ownership of shares and debentures passes to a transferee on delivery of an instrument to transfer signed by the transferor. That's subsection A. Then 4A says from the 27th of August 2001, notwithstanding subsection 4, where the transfer is of shares, the instrument to transfer must be presented to the registrar within 30 days of its execution for the assessment and payment of property transfer tax, which may be payable under the Property Transfer Act or stamp duty that's payable under the Stamp Duty Act, and until, and this is the important point, the instrument to transfer is so presented, the beneficial ownership of shares does not pass to the transferee. Now that was argued before Worrell J. So what
does he not allude to that in paragraph 5? Isn't that what he summarizes as his finding?
Yeah, basically, yeah.
Basically, yes, without, I don't think, naming the subsection.
No, he doesn't cite the sections, but
that's the effect of it.
The singular fact that he finds in paragraph 5 is that the shares remain in Marjorie Knox because, if we look at paragraph 5, so maybe somebody could pull it up, because he says there is no evidence before him of a, I don't know if he uses certificate or instrument or whatever, but I think the language conforms with what we've looked at. Can you pull it up, please?
11.
This is paragraph 4.
854.
854 of the record.
854 of the record.
Yeah.
Thank you.
Yeah.
Justice Jamadah, to answer your question, that is my interpretation of what Worrell J was saying at paragraph 4.
Therefore, you would submit that he addressed his mind to the most relevant consideration in relation to the Order 49, Rule 6 test in the circumstances of this case.
Yeah.
Absolutely.
Is that your submission?
It is my submission.
Yeah. Okay.
So just to continue, as to what was advanced before Worrell J, there was no valid transfer in relation to the Florida Trust, because again, sections 171 and 179. That's to be found at 845 of the record in the notes of proceedings. And there being no valid transfer of shares to the Florida Trust, the appellant remained the shareholder in the 9th respondent. That was the submission made to Worrell. There was therefore no need for service on either Kathleen Davis as trustee or any of the beneficiaries of the trust. That's page 848 of the record. Now, of course, the natural corollary of that is that if there was no valid transfer of shares to the Florida Trust, when Kathleen Davis then subsequently sought to charge the shares under the pledge, the Florida pledge, in 2010, that was quite an impossibility because no shares had been transferred to her. She had nothing to pledge. So the pledge falls away. Now, I'm turning now to the Barbados. I'm just going to summarize in a very high level way the legal documents, again by reference to the legal and beneficial ownership to the dividends. So I'll just go through them very quickly. Barbados Trust, we have 2 or 3 arguments on that. First of all, it was revoked by the Florida Trust. That is page 744 of the record. The Florida Trust, by its express terms, revokes the Florida Trust. I mean the Barbados Trust. Even if it was not revoked, our second argument is that the Declaration of Trust, the Barbados Declaration of Trust, was ineffective in law to transfer any legal or beneficial ownership to the beneficiaries, the intended beneficiaries, being the 2 children under that trust of Marjorie Knox, John Knox and Jane Goddard. So therefore, no legal or beneficial interest passed under that trust. Because Section 179 4A is mandatory. And it is not only mandatory that you present the share transfer and you pay the stamp duty and the transfer tax, but until you do it, no beneficial interest can pass. And that would apply to any declaration of trust, whether it's a declaration of trust from Mrs. Knox personally or another form of declaration of trust. Now it's significant, and I say this maybe in passing, but when you look back at your decision in number CCJ number 8 of 2011, and there's a well-known principle that you can approbate and reprobate. But when you look back in that decision at paragraphs 25 and 26 of that judgment in the CCJ, you will see that my learned friend Mr. Shepherd conceded to this court in those proceedings that this trust, did not either attach to the shares or to the dividends. Now he's arguing quite the opposite. The Florida Trust, that's to be found at page 744 of the record. And the stock power, which is the document which is connected to that trust, the share transfer, the purported share transfer to the trust, page 770 in the record. For the very same reasons that I've advanced, that the Barbados Trust doesn't get off the ground, is ineffective, the Florida Trust suffers a similar fate because there was no valid share transfer that complied with 179 of the Companies Act.
Kingston is a local company.
The stock pledge agreement I've already submitted to you. That fares no better because if the Florida Trust is invalid, then there's nothing to pledge. Kathleen Davis had no shares to pledge to Mr. Allard under the 2010 stock pledge agreement. So essentially, he has no legal or beneficial interest or claim to the dividends under that document.
It's not the Florida Trust is invalid. It's ineffective.
So it's ineffective to transfer
shares.
any beneficial or legal interest in the shares in the Barbados company. That's the point.
That's the point.
The Barbados mortgage, well, we've dealt with that. It doesn't cover the dividends. So what is the conclusion on the documents before Warrell J? Did he act equitably and did he exercise his discretion given all of that which is before him? It is true that he hasn't articulated it in a written decision in the way that I'd expressed it to the court. But inferentially, by coming to the conclusions at paragraphs 4 and 5 of his judgment, he had the documents before him. The natural inference is that he considered them because he said he had regard to that affidavit with the documents. So the natural inference is that he rejected that these third parties had any interest, legal or beneficial, such as would make it necessary for him to order service, or in terms of the language of Order 49, Rule 5, to make an order that the person attend the court, which was never an application made to the court anyway. It was an application for service, but we won't split hairs on that one. So We say that the garnishment order was correctly made. We say that the Court of Appeal, when you look at their judgment, even though it's flawed in some respects, they did consider the documents and came to the conclusion based on the same analysis, essentially, that they were invalid. And contrary to what Mr. Shepherd urged this court early in his submissions, the Court of Appeal definitively came to a conclusion that in the circumstances, because Mr. Shepherd, I think, contended that the question of service was not considered by the Court of Appeal. But he's wrong in that, because at paragraph...
Mr. Gale, you only have a minute or two left, huh?
And I'm very nearly there, sir. I'm very nearly there. Paragraph 23 of his judgment, which is to be found, 23 of his judgment, he says, this is after going through the documents, he says, for these reasons, I hold that the refusal to permit service on the alleged 4 parties was a proper exercise of discretion by the child judge, and this argument therefore fails. So Mr. Shepherd said we were only entitled to a decision on that. We got it. The Court of Appeal gave that decision based on the documents. So we said that was a right decision. The garnishee order was made absolute correctly in Justice Ware's discretion, and that this court should dismiss the appeal. Finally, I'm not going to deal with new points of law, and the reason for that is that essentially the only new point of law that was raised in the Court of Appeal was the issue of exchange control, the only point of any substance. And we do not even need to rely on that to make good our arguments that the garnishee, that Warren was correct in exercising his discretion in not ordering service. In other words, nothing turns on the exchange control point that is not already covered by the invalidating events in not properly having a share transfer, properly adjudicated, stamped, and so on.
Okay.
Yeah,
And
the
the
short
Court
of it, then
Court
you-
of Appeal, Your Honor's asked, did they seek to
Oh,
intervene
finally,
and answer
finally.
that question?
Correct.
Finally,
Right?
and this is important. If you look at the record before Warren J, and you look at the affidavit of John Knox, and particularly paragraph 11 of that affidavit. That's the affidavit found
693 of the record.
693 of the record.
And the notes of proceeding before the Warren J.
Paragraph 11.
Where are we going to say
There
this?
it is. Right.
Page 24.
Look at it. Read paragraph 11.
Yeah, you see paragraph 11, my lords, your honors. There's now shown to me a true copy of the mortgage which my mother gave to Peter Allard to secure loans from him. I'm aware that all the respondents knew the mortgage. I've been told that Mr. Allard has recently been informed of these proceedings, and he was ill during the period before and after the service on my mother. He is now in the process of instructing an attorney at law to advise him in relation to this mortgage. And for that reason, and given his interest, I ask that he be served with the proceedings. So Mr. Allard was clearly on notice. Mr. Shepherd, as the transcript
Page 843.
at page 843 will show,
843.
843 is the record. This is the transcript before Warren. Said,
No comment to it.
it's now coming to it.
843.
He says,
Yeah.
there it is. Right. She's overseas. Mr. Knox has mortgaged shares to Mr. Peter Allard prior to Privy Council hearing. I have been unable to take note the words, full instructions from Ms. Knox and or Mr. Allard, who ought to be aware of the application of the first and second judgment creditors. I arranged to have these documents scanned and sent to Mr. Mackenzie in Canada. That is Mr. Allard's attorney in Canada, who ought to have made that application to Mr. Allard. And then a question is asked there, does Mr. Allard have the right to intervene? I don't know who asked that question. But probably, and then the second point, it cannot seriously be contended that the so-called interested parties did not have notice of these proceedings. And by that I mean Kathleen Davis, John Knox. John Knox was the brother of Kathleen and Jane Goddard, the three beneficiaries. Those are the three beneficiaries. John Knox not only swore the affidavit.
Mr. Gale, I think you run out of time. You need to wrap up now in a minute.
All right, let me then just say this, that all these parties, when you look at the record, clearly had notice of the proceedings before Worrell J. None of them sought to intervene in those proceedings. And you know what? What is significant? 10 years have passed since the determination by Worrell J. None of them, and it goes to Justice Barrow's point, whose interests are you protecting? Why aren't these parties here? None of them in that 10 years have ever sought to intervene in the Court of Appeal or in these proceedings to protect their interests.
Alleged interest.
Alleged interests. And you can ask yourself, why? The rhetorical question, why? But I think it's significant. And that's it. I mean, yes. I'm glad for the indulgence. I've had to rush it, but c'est la vie.
Thank you. Thank you.
Your Honours, I believe I have 15 minutes in reply.
Yes.
I will be quick. First of all, Your Honours, in relation to the point made by Mr. Haynes as to Order 59, Rule 5, that's at 1725 of the record. That is in no way applicable to these circumstances. That is a situation where the garnishee, the person being garnished, is saying that he does not owe the judgment debtor. That is not the situation here. Mrs. Knox has never denied owing this money. There was never denial as to Mrs. Knox owing the money or whatever. Section 5 is completely unrelated to the case. Secondly, Mr. Haynes referred again in that regard to the phrase, it's the same point, if your lordships, if your honours look at it. It's completely nothing to do with the set out. Now, dealing quickly with the set out, the questions that were raised by, I think His Honour Miss Justice Jamadar. If there was an application for a declaration and the court made an order, there would be protection. There is no protection to my client in these circumstances. And secondly, if they were going for a declaration, I am certain that they would have to have joined Allard and the others because they had an interest in the outcome. And thirdly, in the event they just seek to help themselves to the money, that is going to may offend the questions of priorities or gaining an advantage over other creditors. Because they're gaining a priority to which they may not be entitled. Now, passing on, in relation to the point that I think Mr. Justice DeWitt made, it's simply this: you have to follow the chronology. We applied for the documents to be served. Mr. Justice Worrell said no and ruled immediately. So where was the opportunity to intervene? And after the case is due, I'm not at all sure that they have an opportunity to intervene if they have not been given one below, especially in light of Mr. Justice Worrell's argument. we do not, sorry, if I can just look at my notes there. Now, Mr. Gale, first of all, he said that I had said something before and I'm derogating from that now. Honestly, Your Honours, I have no recollection. And I'd really like to be shown that. Because if I'm going to say that a lawyer has done that, I'm going to be sure that I take that lawyer to the exact paragraph so that there is absolutely no doubt. I have no recollection of saying that. If I am wrong, then I would really have to apologize. But the other point is this. Mr. Haynes took you to the history of this matter and talked about attempts to frustrate and all the rest of it. Those are the points that were raised in the affidavits filed on the 9th and the 10th, to which we sought time to respond. And Mr. Haynes said they played no part in the decision. And now, at the 25th hour, Mr. Gale is saying that they justify the decision. Those very affidavits that we complained about. And to make these kinds of allegations about multiplicity of proceedings, about frustrating, again, attempts to somehow slander my client without in any way condescending on the actual details of this matter. And simply put, Your Honours, this is the point. Mrs. Knox did not sell at a price which was close to what she was entitled to receive by way of a first dividend. She then brought a case saying that there was that her interests as a minority shareholder were being oppressed, which is yet to be determined, and which was put on hold because the respondents made an application, which I'd said was of no merit, to halt those proceedings until this appeal was dealt with. And the multiplicity of proceedings include proceedings brought by the respondents. I ask you and I plead with this court not to take these kinds of accusations because, first of all, they are irrelevant. Secondly, we were not given an opportunity to respond. And thirdly, they are no more than an attempt to justify the Court of Appeal's use of the word sordid, which is not internecine. Sordid is sleazy. Now, Your Honour, Mr. Justice Ramadar asks a very pertinent question. Did Justice Worrell address his mind to all the material considerations? And you were answered and you were told, yes, section 179 covers it. Mrs. Knox is in fact the registered shareholder. That was a point I think your president, the Honourable Mr. Justice Sanders, made. We, for one moment, do not deny that Mrs. Knox is the registered shareholder in the company's books. We do not for one moment say that as between company and Mrs. Knox, the dividend is rightly paid to Mrs. Knox. But that is not the issue. The issue is whether, given the nature and kind of properties in the dividends in the hands of Mrs. Knox, was it correct to make an order garnishment? And we say no for the reasons of Death, for the reasons of Oyster and Fraser, for the reasons of Nadal, all of which cases we have cited. It is the question as to the ownership of the shares is not the only question. The question is, what is the property in the dividends in the hands of Mrs. Knox vis-a-vis third parties? Now, my learned friend said...
Mr. Shepherd, did you say earlier that, yes, Mrs. Knox is a registered shareholder, and yes, she's entitled to the dividends, but did you say that?
Yes.
Okay.
She is entitled, because vis-a-vis herself and the company, there's no question about that.
Okay.
The company gets a receipt for its dividends from paying Mrs. Knox. There's no question about that. But that is the point about Section 171. You don't put the company on notice of shares, of trusts. That does not determine the rights of the parties to the money in the hands of Mrs. Knox.
And that is between Mrs. Knox and those parties.
Yes. It has nothing to do with the company.
All right.
Nothing.
Yeah.
Mrs. Knox.
And these garnishing proceedings were brought by?
They were brought by the second Classic and Deane.
Yeah. Okay.
And the set off then by Kingsland.
Yeah.
So the question is whether Classic and Deane are entitled to get those dividends over and above any documents that Mrs. Knox did in relation to those, to her rights to that money vis-a-vis third parties. And that is what was never considered by Justice Worrell.
But Mr. Shepherd, if Mrs. Knox owes the company monies.
Yes.
And the company has dividends in its hands.
Correct.
For Mrs. Knox.
Correct.
What is there to prevent the company from, whether you want to say setting off or withholding, what is there to prevent the company from taking into account this debt that Mrs. Knox has to it before it pays her?
I understand, Your Honor. The difficulty I have with that is this. Let us assume that Mr. Allard sues Mrs. Knox in Barbados. And the company has done no more than withhold. Mr. Allard would be entitled to sue the company.
But he could still do that now.
No, Your Honor, not with an order. There is an order in place. Now.
But can't he sue to have that order set aside? Particularly
how can he?
As the monies have not been disbursed. They are in court.
Because that would be a collateral attack on the judgment of the court.
No, but can he not intervene to say, I am a party who has an interest in this money. My interest should take priority. Why not?
Not at this stage. It's over. The court has made an order.
You mean the order absolute?
Yes.
Mr. Shepherd, I have the utmost difficulty in accepting that proposition, because what is done as between two parties to litigation does not necessarily bind a different party altogether who is not a party to that litigation, especially when that order is made in the course of enforcement proceedings.
I understand the point Your Honor is making.
Actually, Mr. Shepherd, I quite liked your reference to the Dresdner Bank, etc., where one tribunal altogether, albeit in a different jurisdiction, can say, okay, what took place in those proceedings, we're not paying any attention to that. Certainly, in Barbados, within the same jurisdiction, a fresh court sees of a matter as between different parties can say, what was done in other proceedings did not take account of what is now before us, and we are going to make an order, etc., etc. So I don't buy it.
Your Honor, please, I am not sure Your Honor is completely right. For this reason, there are issues of estoppel. And I think estoppel applies, certainly, first of all, I think I'm right in this. Estoppel applies certainly to parties to litigation on any points that they could have taken in that litigation.
Yeah, but Mr. Allard would not have been a party to that other litigation.
Yes, I'm just about to deal with that, Your Honor. My point is this, is that I am not sure that it does not also apply to parties who could have intervened. And the point keeps on being made to me, why didn't they intervene? And I keep on saying, we asked for service. We expected that there
Mr.
would
Shepherd,
be
Mr. Shepherd, you asking for service cannot be an answer to a party's duty to protect their own interest. What you do is they may tell you thank you, you may be a gentleman of the highest honor, that's fine, but they have a right to protect themselves. What the record, I think, shows is that I think your very affidavit or your disclosures to the court demonstrate is that they themselves were served with the papers. When I say served, were given notice of what was going on, and they were taken advice, and they chose not to intervene to protect their own interests. So why should Justice, just a minute, why should Justice Worrell, if the companies act, and you say that as far as the company is concerned, Mrs. Knox was the registered shareholder and she is entitled to the dividends, and it is not the business of the company what trusts or otherwise may exist. That's what you've told us. It's not the business of the right. And if Mr. Knox chooses not to come and say, look, Justice Worrell, take a pause. Court of Appeal, take a pause. File a new claim. I have an interest. I want a declaration. I am like my brother, Justice Barrow, I must confess that I am not connecting the dots.
Yeah, except
but it may be our weakness, and let me not speak for him, it may be my weakness. He has few weaknesses, but it may be mine.
Your Honor is not taking into account that no opportunity was given for that.
Mr. Shepherd did what? Just a minute. Was he aware of what was going on?
Who, Your Honor?
Mr. Knox.
Mr. Allard.
Yes.
Mr. Allard, sorry.
Yes.
All right, so just a minute. What you mean no opportunity was given? Did he make an opportunity? Well, I'm sorry, let's not bother on it. I am pressed to connect the dots. I will reflect.
With respect, Your Honor, please just allow me to answer Your Honor in this way. Let us assume that Mr. Allard and the others were aware of what was going on. Let us assume that they were aware of the fact that an application was being made, that these documents ought to be served on them. Were they not entitled to await the outcome of that application before deciding whether or not to intervene? And if they were so entitled, they would not have had an opportunity to intervene between the decision that was given and the garnishee nisi, is my simple point.
And Mr. Shepherd, I want to tell you that they could have made an application even after that order was made, because there's not anything which makes a judge incapable of reversing an order made in the absence of a person who ought to have been heard. So if natural justice required that the judge should reverse his order upon an application made by Mr. Allard himself, he could have done it. More importantly, I think you should know, certainly more than I do, that a person can apply to become a party to an appeal when they were not even party to the first instance proceedings. I have done it, and I'm sure you have done it or come close to doing it. So quite frankly, I will not argue the point with you. I'm simply saying to you the thoughts which are occurring to me.
Yes, of course, and Your Honor is correct, except that I deal with this matter. The appeal was always on the question of fair hearing.
I say I will not pursue the point. I thank you.
Yeah. Okay. The other point I wish to make, and it is just by way, is that none of these arguments are, I think, addressing the cases of Deane, Oyster, and Nadell, and the others to which I have drawn attention. None of them. I don't think I can be of further assistance, Your Honours.
Yes. Thank you very much. Thank you very much, Mr. Shepherd. The court naturally will reserve its judgment in this matter, and we will let you know when we are going to deliver it.
And not for 4 years.
You could bank on that. Richard and Counsel for the submissions, and I bid you good afternoon. Madam Deputy Registrar, you may close the proceedings.
Thank you, Honourable President Saunders. Thank you, Honourable Mr. Justice Witt, Madam Justice Rajnath Lee, Mr. Justice Barrow, and Honourable Mr. Justice Jamada. Thank you, Counsel. I thank you, staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Good day.
Good day.
Good day.
Thank you.